On behalf of the Noble Lord Hain, who's unable to be in the House today, I rise to move Amendment 103 in his name and in the names of the Noble Baronesses Lady Wheatcroft and Lady Altman and myself. In doing so, I pay tribute to Lord Hain's tireless efforts in exposing corruption and particularly the key role he played to bring the kleptocracy of former South African President Jacob Zuma to the world's attention. The effect of the amendment we are discussing would be to require the UK government to begin negotiations for the establishment of an International Anti-Corruption Court, or IACC, within 6 months of the passing of this bill. International corruption is estimated to cost $2 trillion or 5% of global GDP each and every year. In a 2021 report, the UN's high-level panel on international accountability, transparency and integrity calculated that as much as 2.7% of global GDP is laundered by criminals through illicit global financial flows. While these opaque transactions occur in all countries, they have a much heavier impact on low and middle income countries. Global Financial Integrity, a Washington-based organisation, found in its most recent report that from 2004 to 2013, developing and emerging economies lost $7.8 trillion in illicit financial flows. That is around 10 times more than the entire sum of foreign aid, including, of course, aid from the UK, that they received over the same period of time. And as illicit outflows are increasing rapidly at an average rate of 6.5% per year, nearly twice as fast as global GDP. A substantial proportion of that corruption comprises theft by a nation's leaders of state funds for their own use. In other words, kleptocracy. Putting an end to that kleptocracy and recovering assets stolen by corrupt leaders would enable millions of the poorest in our world to be adequately housed, clothed and fed by helping to prevent national treasuries being looted to line the pockets of corrupt politicians and their business cronies. That so many kleptocrats succeed is not because of a lack of domestic laws. There are 189 parties to the United Nations Convention Against Corruption. Most of them have complied with their obligations under the Convention to have appropriate domestic anti-corruption legislation. But to facilitate their criminal activities, kleptocrats have gutted their domestic criminal justice systems, they've taken control of the prosecuting authorities, the police, and frequently the courts. There's no better current illustration than President Putin, who with his oligarch accomplices has looted the country. Another prime example, which I've mentioned already, is former South African President Jacob Zuma, who with his business cronies, the Gupta brothers, looted on an industrial scale and deliberately disabled police and prosecutors, so much so that the country was estimated to have lost fully a fifth of GDP during his infamous state capture decade. Across the border in Zimbabwe, the ZANU-PF regime is mired in corruption, which has robbed the Zimbabwe people of what should be a bright economic future. Instead of serving the people, regime leaders, aided by corrupt business people and a prosecutorial and judicial system entirely captured by the ruling party, loot the country at will. Just last week, opposition politician Jacob Ngaravuma was sentenced to 4 years imprisonment simply for calling for peaceful protests against corruption in July 2020. Few of these kleptocrats, of course, keep their ill-gotten gains at home. Billions of dollars of stolen assets are laundered in a number of countries, which include China, Hong Kong, Dubai, Singapore, Monaco, Switzerland, some states of the United States, UK overseas territories, and shamefully also London. Recently, an Al Jazeera document, Gold Mafia, secretly filmed Zimbabwe officials and business contacts conspiring to launder illicit funds. Those filmed included at least 3 British citizens, Ubud Angel, Ricky Doolan and Kamlesh Patni, who made clear on camera their willingness to act corruptly. Now, I know, of course, that the Minister will not be able to comment on those individual cases, but I hope that the National Crime Agency is investigating the activities of these individuals and others named in the documentary, and the sources of their wealth, and that the authorities won't hesitate to freeze their funds while these investigations are being pursued. However, whilst British authorities can act on crimes committed under UK jurisdiction, there is no international mechanism to prosecute kleptocrats and to seize and return their illicit funds. This gaping vacuum can only be filled by establishing an international anti-corruption court that can hold corrupt leaders and their co-conspirators accountable. If some of the countries where laundered funds are held would join such a court, the stolen assets could be frozen and then, through orders of restitution, be repatriated to the countries from which they were stolen. And if the risk of those funds being misused, if returned to a corrupted state, are too high, they could be repurposed and repatriated only at a time when they would reach the real victims, the millions in need in those countries. The envisioned court would have jurisdiction over crimes committed by nationals of an IACC member state and crimes committed in the territory of an IACC member state. It would enforce existing national anti-corruption legislation and be a complementary new international counterpart to these laws against kleptocrats and their collaborators. The IACC would be a court of last instance, meaning it would have acquired jurisdiction only in cases in which the appropriate domestic authorities are unable or unwilling to investigate or prosecute the corruption. For the IACC to succeed, it would not be necessary for the countries governed by kleptocrats to join the court. It goes without saying that they would not. The IACC could be established by treaty and quickly become effective if it consisted initially of even a relatively small number of representative states, as long as they include some financial centres and other attractive destinations where kleptocrats frequently launder, hide and spend their stolen assets. In this way, the IACC would have the potential to prosecute, punish and recover illicit assets from kleptocrats who rule or are very powerful in the countries that might not initially join the court. Most importantly, the threat of criminal prosecution at the IACC would deter other potential crimes of grand corruption by leaders who may otherwise be tempted to emulate the example of the kleptocrats. The cost of the IACC would constitute a small fraction of the amount of illicit assets that it could seize and return to their originally intended purpose for the public good. In addition to orders of restitutions, it could levy funds on those found guilty, and these could be used to defray some of the cost of its prosecutions and proceedings. If the court during its early years demonstrates that it can work effectively and efficiently, many other countries are likely to join it. In the aftermath of kleptocratic government, some developing countries may not have the human and financial resources to fight kleptocracy and could approach the IACC to come to their assistance. A senior United States federal judge, Judge Mark Wolf, is leading a campaign to establish such a court. Together with others, including the renowned South African jurist Richard Goldstone, he launched a civil society called Integrity Initiatives International. Its main project is to establish the IACC, and it's convened a number of the world's top international lawyers to begin drafting a treaty for the court. None of its supporters see the court as a panacea that will end kleptocracy any more than the International Criminal Court has ended illegal or genocidal activity by political leaders. But it would be one of many tools, domestic and international, that are absolutely essential to combat and hopefully ultimately defeat kleptocracy. Almost 300 leading figures from across the world, including 45 former presidents and prime ministers and 32 Nobel laureates, have signed a declaration calling for the creation of the IACC. 3 governments have made the establishment of the court an element in their official foreign policy: the Netherlands, Canada and Ecuador. In January this year, Nigeria became the 4th country to publicly state its commitment to working with other states towards the establishment of the court. And recently, the President of Moldova, Maia Sandu, also committed to joining the emerging coalition of states for the IACC. Additional countries from each region of the world have also expressed their interest in the idea. My Lords, the United Kingdom and our legal profession has always led in establishing and participating in international courts of last resort. This started with the groundbreaking Nuremberg trials and went on to include the International Court of Justice and, of course, the International Criminal Court. The government's integrated review refresh, published earlier this year, committed the UK to championing global efforts to ensure that revenues and assets lost to illicit finance are identified and recovered so that low and middle income countries can self-finance their own development. And this commitment was reiterated by the Minister for Development in Africa in his Chatham House speech on the 27th of April, when he said, "We will bear down on money laundering and the flows of dirty money which deprive countries of their legitimate tax receipts and represent money stolen, particularly from Africa and the African people." My Lords, we must live up to these commitments. I therefore urge the government to accept our amendment and ensure that the UK becomes one of the early and leading supporters of the establishment of the IACC, lending the UK's weight and expertise to finding the fastest route to the creation of the court and the most effective framework for its operations. My Lords, I beg to move.
Amendment proposed. Insert the new clause as printed in the Marshall list.
My Lords, I rise with great pleasure to follow the noble Lord Oates with a very powerful, persuasive and rich speech. And I join echo the noble Lord in paying tribute to the noble Lord Hain for all of the work he's done in this area. Now, the noble Lord Oates said that, acknowledged, I think absolutely rightly, the International Anti-Corruption Court, which I would absolutely back, and I think clearly is growing by the day, the backing for it. The noble Lord said this is one of many tools that we need to tackle these issues of economic crime. What I'm seeking to do with my Amendment 106A is to put in another tool in the toolkit, a tool that perhaps at the moment is in a stage of prototype and rather earlier development than the International Anti-Corruption Court, but is one that is growing fast and has significant international backing. So what this is I'm proposing that the government should provide leadership in supporting the UN General Assembly Resolution 77244, which was passed right at the end of last year, 30th of December, with the leadership from Nigeria and the Africa Group, which calls on the Secretary-General to prepare a report on how to, quote, strengthen the inclusiveness and effectiveness of international tax cooperation. This has been seen as a step towards a UN convention on the issue and the establishment of international bodies to enforce it. And I hope that some of the noble lords taking part in this debate today or reading this later would be interested in joining me in pushing this forward as an issue that clearly Britain can, could and should be a leader in. Now, I have, due to the limited scope of this bill, had to cut down somewhat what the General Assembly resolution says, but I still think there's steps that we can take forward going here, and I'll be very interested in hearing the noble Lord the Minister's response to the government's response to this UN General Assembly resolution. Because I think it's very clear, following on from what the noble Lord Oates said, that chasing economic crime money, chasing perhaps particularly tax evasion, is what's known in the jargon as a wicked problem. The aims of the evaders are simple, their reach is global, the ability to act is measured in seconds. Money can be shifted with less than the click of my fingers. Whereas nation-states have very complex goals of development, rights and the rule of law, their powers are individually restricted within their own borders, their legal framework is limited in resources, as we were discussing in the last group, and frequently takes a lot of time to move into action. So I think it's worth looking at what Atiya Warris, the UN independent expert on the effects of foreign debt, told the UN General Assembly last year. The shortcomings of the international and national tax systems require international cooperation and assistance. This cannot be addressed unilaterally. And I think the UN Convention, the idea of the UN Convention's got virtually no coverage or attention in the UK, but internationally there's a great deal of work going on, as reflected by a letter sent in March to the UN Secretary-General by scores of civil society organisations, which included some that will be familiar to noble lords, ActionAid, the Tax Justice Network, and World Economy, Ecology and Development. That letter, put it bluntly, decision-making on global tax rules has been left to non-inclusive forums, wherein especially developing countries have not been able to participate on an equal footing. This injustice is at the heart of the failure of the international tax system, which has continued to be characterised by inefficiency, incoherence and beggar-thy-neighbours policies, which have contributed to the alarming growth in global inequality. Now, what I wanted to do was put down a broader amendment that addressed all aspects of the UN resolution, because I think that what is not actually illegal, tax dodging, is utterly indefensible. Taking money from the mouths of hungry children, taking medicines from health systems that are desperately striving to care for their people. But I've gone as far as I can within the limits of this bill. Now, there's a great deal of work has already been done on this. The proposal for a UN Convention on Tax was published by the Global Alliance for Tax Justice and the European Network on Debt and Development in March 2022. That draws on examples. A lot of this, there are pre-existing parallels in governance structures, approaches and principles from the Rio Conventions, international human rights instruments and the WHO Framework Convention on Tobacco Control. And I think it is worth setting out the background to this, because it has been said that let's leave this to the OECD. The OECD has said we're the organisation that should do this. It's over decades, under its framework, it's had a international tax regime whose main purpose was to prevent double taxation. That's what the focus has been. Not collecting tax, but preventing so-called over-collection. It also excludes the majority of the world from its deliberations. So we hear often talk of global Britain, of wanting to be world leading. Well, here's a real opportunity. As Professor Lorraine Eden from the University of Texas A&M puts it, quote, large changes in international regimes usually require a tipping point and the cooperation of a like-minded club of nation states to lead the change. What my amendment does is suggest that Britain should put itself at the forefront of that club of nations. We have the City of London, we have a great many lawyers and bankers and lots of other people who, pointed in the right direction, could be very useful to that effort. Competing in a world of laxer and laxer tax regimes has been a disaster for people and planet, an invitation to crime and corruption. Cooperation has to be the way forward to equip the world with the funds to tackle the looming polycrisis of environmental destruction, human desperation and rampant inequality.
My Lord, I speak to Amendment 103, and thanks to the comprehensive introduction from the Noble Lord Oates, I can be relatively brief. The International Criminal Court in The Hague was established in 2003. Later this month, it will take evidence from representatives of some of the victims of the war crimes in Darfur. That's typical of the absolutely essential work that the International Criminal Court can do. It's no wonder that there are now calls for Putin to be indicted to the International Criminal Court. Few today would question the need for such an organisation. And now it seems clear there's a need for an international anti-corruption court. The Noble Lord Oates made the case very positively. Kleptocrats are the financial war criminals, inflicting huge damage on their countries. But like the dictators who commit genocide and other war crimes, they have impunity to act as they wish in their home countries because they control the police, they control the prosecutors, they control the courts. The damage their greed inflicts on their countries is huge, but those countries are rarely able to bring them to justice. That's why this new court is so absolutely essential. The Panama Papers, the Pandora Papers, they provided appalling glimpses into the scale of the corruption which senior officials in many jurisdictions have been involved in. And the proceeds are scattered around the world. The International Anti-Corruption Court would provide a mechanism for prosecuting those individuals and retrieving those funds. My Lords, the United Nations has demonstrated the ineffectiveness that it has in this area. The General Assembly adopted the UN Convention Against Corruption in 2003, getting on for 200 countries who signed it. But sadly, those signatories include most of the worst offenders on Transparency International's corruption index. Too many countries treat the convention with contempt because their leaders and their senior officials preside over corruption-rife regimes. That's why we need this court and why I put my name to this amendment. It could be set up relatively quickly. It could be hugely effective. Its very existence would deter corruption. So I ask the Minister, if the government wants to fight corruption, why would they not support this project?
Of course, I echo the concern that's been expressed in speeches so far about international corruption on an enormous scale. We've been focusing on our debates very much on what happens here in the United Kingdom. And I think that in our attack, I have to say, very much on the government, it's worth bearing in mind that actually in 2016, this government hosted an international corruption summit hosted by the then Prime Minister, so many Prime Ministers ago, David Cameron. And it was partly as a result of this that we then had the Criminal Finances Bill, and there was an impetus, sadly a very slow impetus, to set up a register of overseas entities, because it was felt that, at least in this country, we could do all we could not to allow our property, the companies that run to be infected by corruption. And indeed, what this bill is seeking to do is to improve what has already been achieved. It hasn't gone far enough in many ways. But this is, I would respectfully submit, pretty aspirational stuff that's contained in this amendment. There's nothing wrong with being aspirational, but the International Criminal Court, and I've been to conferences of the International Criminal Court, has had some success. But it must be remembered, of course, that Russia is not a party to the International Criminal Court, nor is the United States. And it's one thing to say it's relatively easy to set up a court. You have to have proper means of enforcing it. You have to invest huge sums of money in infrastructure. There has to be a degree of realism about this. Surely, my lords, what we should be doing first of all is sorting out matters at home as best we can, which will in itself contribute to helping reduce international corruption. I think putting on the statute book, which is what this is suggesting, an obligation to set up an international a court of this sort is at this stage premature, although of course one can do nothing but applaud the sentiments that lie behind it.
My Lords, this has been a very interesting debate, and it's the first debate really we've spoken on a more international level. And as we've heard in a number of earlier groups, the actual quantity of money involved in fraud, a very large proportion of that, well over 90%, probably 99%, has an international element. So really that is at the core of so much of the fraud with which we're dealing. I congratulate the noble Lord Oates on the way he introduced this group. I found his introduction rich and compelling. He set out things very fully, and I think that the other noble lords who've spoken have spoken about the aspirational nature, and I don't think that's a criticism of the amendment. And it is good to hear about the other countries which are already taking a lead in trying to get the IACC set up. My Lords, from the Labour Party's point of view, I have looked at what David Lammy has said on this matter, and he has spoken about working internationally, of course, and I know the Noble Lord Hain led the work on that when he was a Foreign Office Minister. But what I've got here of what David Lammy has talked about is promised. He has said any incoming Labour government would fight against the dirty money in the UK by creating a transatlantic anti-cooperation council along the US, EU and other allies. So that's a different model to the one which is being proposed in these amendments. Nevertheless, I don't want to stand here as an opposition spokesman saying we are against what's been proposed by the Noble Lord Oates and indeed by the Noble Lady Baroness Bennett. But there are other potential models for bearing down on corruption, and I do listen with some interest, I have to say, to what Noble Lord Falk said about the practicalities of doing this and using the legislation such as this, which we're talking about now, to do everything we can on a domestic level and also internationally where we do already have direct interest to bear down on this huge level of corruption. But nevertheless, I thank the Noble Lord for introducing this amendment.
My Lords, I'd like to thank the Noble Lord Hain and the Noble Baroness Lady Bennett for their amendments in this group, and to all Noble Lords for speaking in this debate. And turning first to Amendment 103, tabled by the Noble Lord Hain, but spoken to by the Noble Lord Oates. And if I may associate myself with Lord Ponsonby's remarks, I thought the Noble Lord made an incredibly powerful and eloquent case, but also spoken to by Baroness Bennett and Baroness Wheatcroft. Ensuring that those responsible for the most egregious acts of corruption are held to account is obviously vital. There should be no tolerance towards those that steal from the public to satisfy personal greed. The government wholeheartedly endorses the premise that this amendment seeks to advance. The international community can and must do more to deter and punish acts of corruption. So the government is taking robust action to ensure the UK leads by example. That's why in March we published the second public-private economic crime plan, to which I referred in the last group. That outlines ambitious actions to prevent the UK's open economy from being exploited by criminals and corrupt actors. The government is also developing a new UK anti-corruption strategy to build on the progress made by the previous strategy and outline a refreshed approach to tackling corruption and illicit finance in the UK and internationally. The recently published fraud strategy also sets out the government's commitment to raise the priority of fraud on the international stage. We will drive forward global action through developing stronger relationships with international partners, culminating in a global fraud summit chaired by the Home Secretary and held in the UK next year. The summit will bring together leaders from governments, law enforcement and the private sector to announce the ambition to deliver a comprehensive and coordinated approach to tackling fraud over the next 5 years. The government has consistently invested in efforts to bring those responsible for corruption to justice. The International Corruption Unit in the National Crime Agency is a specialist capability that investigates corruption cases with UK links. Since 2006, 30 people and companies have been convicted.
I thank the Noble Lord the Minister for giving way. Just on the point of that summit, the problem, of course, with the idea of such as was put forward by the Noble Lord from the opposition front bench about a transatlantic council or similar is that it would be focused on global north countries. Can the Noble Lord the Minister assure me that there will be a full representation of global south countries at that summit that the Noble Lord just outlined, and that the UK will provide resources to ensure that some of the least developed countries, who are some of the biggest victims of this, are also able to participate in that summit?
I can't provide that reassurance. I don't know who is going to be involved, but I will endeavour to find out and write, if I may. Where was I? In addition, the UK leads and hosts the International Anti-Corruption Coordination Centre, that's the IACCC, which brings together specialist law enforcement officers from multiple agencies around the world to tackle allegations of corruption. the IACCC has helped to secure convictions in high-profile money laundering cases, including in Malaysia and Angola. In 2022 alone, the IACCC identified over £380 million worth of stolen and hidden assets. I think I forgot to mention a piece of my previous paragraph, which is that since 2006, 30 people and companies have been convicted of corruption offences, and over 1.1 billion of assets stolen have been frozen, confiscated or returned to developing countries. That's in relation to the International Corruption Unit in the NCA. Having said all of that, there is no doubt that more needs to be done to combat corruption, and the government is not the government, as I'm afraid, is not currently able to endorse the creation of a new bespoke institution in the form of an international anti-corruption court. The FCDO has been actively engaging in international discussions on this subject over the past year and will continue to do so. It is clear from these discussions that there is a lack of international support for an international anti-corruption court, and this is currently a significant barrier to its likelihood of success. Greater international consensus on the need and mandate of an international anti-corruption court is required before international negotiations on such a body can be considered. It's also important to note that an international anti-corruption court would come with significant financial implications. So as a comparison, the operating cost of the International Criminal Court for 2022 was approximately €160 million. Before establishing an international anti-corruption court, we would need to be confident that its impact would justify such a cost. While the government is not able to support this amendment, the Noble Lord should be commended for raising this important issue, because the government remains committed to holding the perpetrators of corruption to account. Ownership of international treaties and jurisprudence sits with the FCDO, and I know that my ministerial colleagues there have noted the interest in this amendment and would welcome further exchanges with the Noble Lord to consider the options available to accelerate international action. The government...
Conscious that I didn't contribute to the debate in this, but is it too late to get the word anti-corruption into the communique for the pending G7, which takes place between the 19th and the 23rd of May in Hiroshima? Because that word is not anywhere in the foreign minister's communique when they met in April, I think it was April the 19th in Japan, and their communique covers almost everything that you could imagine that we would be interested in involving those countries that share our values, but it's not there.
The Noble Lord won't be surprised to know that I don't know, but I'll ask. The government will endeavour to update your Lordship's House on its plans for progressing international action on corruption in due course. So I hope the Noble Lord and Lord Hain and Lord Oates on his behalf are reassured by this government's commitment to combating corruption. We look forward to further discussions on the subject and to setting out our plans in further detail at an appropriate time. So I would therefore ask the Noble Lord to withdraw his amendment. Turning now to Amendment 106A, tabled by the Noble Baroness Lady Bennett. My Lords, the government cares very deeply about tackling tax evasion and avoidance. My ministerial colleagues continue to work closely with the various subcommittees that sit within the UN's Economic and Social Council. However, standard-setting powers on tax currently sit within the Organisation for Economic Cooperation and Development, the OECD, its inclusive framework and global forum. And the UK believes that this is the mechanism best placed to deliver consensus-based reforms aimed at tax avoidance and evasion. The Inclusive Framework and Global Forum both have wide and diverse memberships of over 140 and 160 countries respectively. Furthermore, the OECD holds strong technical expertise in matter of international tax avoidance and evasion, and a potential UN convention on global tax evasion, as envisaged by this amendment, would duplicate and likely hinder the OECD's work. My Lords, this would delay the coordinated global response and effort to address tax evasion and avoidance and combat harmful tax practices, as well as creating divergence in international tax standards. Having said that, the UK will engage constructively with the upcoming UN Secretary-General report. We want to find ways to improve international cooperation, as I've said, but to do that we want to ensure that this captures the full range of existing mechanisms for international tax cooperation and considers creatively how these could be improved to better meet developing countries' needs. We've submitted evidence to the UN Secretary-General demonstrating these points. My Lords, having said all that, I would obviously ask the Noble Lady not to move her amendment.
My Lords, I thank all members who spoke in this debate and particularly thank the noble Baronesses, Baroness Wheatcroft and Baroness Bennett for their support, and I also am sympathetic to the amendment moved by Baroness Bennett. I'm also grateful to the Minister and to the noble Lord Ponsonby for their thoughtful responses. I'm disappointed, obviously, by the Minister's conclusion, but I hope, as he suggested, we can continue those discussions going forward. I want to reassure the noble Lord Fuchs that my purpose wasn't to come as a critic of the government. Indeed, I highlighted, commitments made by the government in the integrated review refresh, and I commend the Minister for Development for Africa for his real focus, because he understands how important this, compared with overseas development assistance, that is nothing compared with getting this right. I'm not sure I share his views on the International Criminal Court and other international criminal tribunals. One of the great proponents of this international anti-corruption court is retired Justice Richard Goldstone, who was the chairman of the International Criminal Tribunal on the former Yugoslavia, which of course convicted a number of key figures, Ratko Mladic and Karadzic. So it does have impact. And also, we should be aware that even for the non-signatories of the ICC, it has consequences. It has consequences for President Putin that he has been indicted. It has consequences on whether he can travel to BRIC countries that are members of that, who are signatories to that court. And on the charge of being aspirational, I plead entirely guilty. You can't get real change in the world unless you're aspirational. And of course, as I said in my opening speech, this isn't a panacea. It is one tool, and one of the most important things, as the noble Lord Fuchs said in his remarks, is of course the enforcement powers we have in the UK, which we're not using, in my view, as much as we should be, and I hope that through this bill and through other means we will do more, but much more on enforcement, as in the previous debate on amendments we've heard. This is really about the mechanisms to enforce lots of things. It's not about the laws. There's loads of laws on this stuff generally. It's enforcement mechanism. The International Court would be another enforcement mechanism, but of course we need enforcement mechanisms at home. But with that, I thank everybody who's taken part in the debate, and I beg leave to withdraw the amendment.
Is it your Lordship's pleasure this amendment be withdrawn? Amendment by leave withdrawn.